Okay, let's go on the record on cause number DC 2016686. Lewis v. Lindsay. Council, make your appearances.
Brandon Mason for the plaintiff.
James Cruz on behalf of the defendant.
Okay, we have a motion for attorney's fees today. I thought I'd already ruled on this, but I'm happy to hear from you guys.
Yes, Your Honor, that is coming from us.
Before we start, may I interrupt? I'm sorry, Brandon.
Absolutely.
I did not receive notice of hearing for this, just so the court is aware. It wasn't served to me. I was not even served with a copy of the proposed order. I also wasn't served with Mr. Mason's communication. Apparently, he sent exhibits to the court, I'm assuming earlier today. I was not served with copies of those with the correspondence. I received an email about 30 minutes ago from him telling me that he had previously submitted those to the court. So I want the court to be aware I do have an objection on file regarding lack of notice for this hearing.
Did you not send him notice, Mr. Mason?
Well, I did send the exhibits for this hearing that he's talking about within minutes. At the same time, I sent them to the court. As far as this hearing, we didn't send notice for this hearing because, and this is honestly something that kind of confused us. You mentioned that you had already ruled on this, but this topic wasn't covered in the order that you had issued. So we had filed a proposed order to cover this, and I contacted the clerk's office, or sorry, not the clerk's office, your court, to find out about an entry when I went to check on our filing, where it just said may require a hearing, and I was informed that you would be requiring a hearing on it before you would rule on that one, and then just said proposed like a date that we could accommodate a hearing. And I'll definitely concede I assume that was something coming from the court, and that we would be issued like a formal notice of hearing on that one. But all I did was, file that order to cover what wasn't covered in the defendant's order that you had already denied, and then stated what date would work for me once it was made clear that you would want a hearing on it before ruling.
So maybe I just want to make sure we're kind of all on the same page here. So
Absolutely.
This is the order I issued. Have you guys seen this order?
Yes, Your Honor.
And I denied the TCPA motion, but there was also a request for attorney's fees, and I crossed all of those out. I understand I kind of talked briefly during the hearing about whether or not this would be considered a frivolous motion, but I thought about it. It's not. I don't think it's frivolous. I don't think it's. Obviously, I didn't grant it, but not every motion that's filed is frivolous just because I deny it. And so, is there something that wasn't covered in this motion that needs to be covered?
Well, Your Honor, the motion that you have on the screen right now, it denies the defendant's request for attorney's fees pursuant to the TCPA, but it was silent on our request that we had filed in our response. So that was why I went ahead and filed to get an order on just that specific part, because it wasn't covered in this one. So I had thought that it was just not ruled on because it was omitted from defendant's motion, naturally.
No, I'm not going to grant attorney's fees. I mean, the standard for frivolous to me is such a high standard. I disagree that the TCPA applies here, but I don't think it was a frivolous motion. And so, if you wanted an order specifically denying that, I can grant one. But or Mr. Cruz, if you just want to reset this hearing, we can do that too. But it seems to be kind of.
Well, I'm not asking for. I mean, it's Mr. Mason is asking for attorney's fees, alleging that our motion to dismiss was frivolous. I think that it's improper to have this hearing. I think there's no reason to have this hearing. I agree with the court that it wasn't frivolous, and
But if
even
you,
though last
Mr.
second I prepared. reasons why.
So, Mr. Mason, if you want to prepare, or Mr. Cruz, if you want to prepare a hearing, an order that says that I've specifically denied the plaintiffs and the defendants' requests for attorney's fees or something like that, I'm glad to sign that. I don't know that it's necessary, but if you all have a higher comfort level with that, I'm glad to sign something like that.
On my end, that's perfectly fine. If Mr. Cruz would like to just incorporate the language in our motion
No,
into his, and then you can just issue a singular order.
no, I'm not gonna, I didn't ask for it. I would,
All right, Mr.
if they
Mason,
want
you
to
go
do
ahead
the
and
work,
prepare
they
the,
can.
Okay, well, that's fine too. I'm perfectly fine to do the work on that front. Just seems like essentially, Your Honor, it's safe to say you're denying literally everything with respect to this for both parties.
correct.
Your Honor,
No.
before we close, I just request that I begin getting served by.
Yeah, whenever you request a hearing, Mr. Mason, you always need to notify the other side. The clerks aren't going to usually do that. So you need to notify the other side, unless it's like a DWAP hearing that we've set. You need to notify the other side about the hearing.
And the proposed order that if you submit one as well, please.
And if you submit a proposed order, you need to submit it to the other side as well.
I'm going to make sure to be on top of that. That's my mistake. My apologies, Your Honor.
No worries. All right, guys, you guys be
Thank you, Your Honor.
safe. Just give me an order and email it to my court coordinator, as well as e-filing it. And on the order, just say on April 26th, the court, just make it clear that the only thing we need in there is just the court has, in an abundance of caution, has denied attorney's fees for both sides in this case. Make it really simple, but do include today's date on the order.
Absolutely fine with you, Your Honor. Thank you.
Thank you,
Your Honor.
guys.